we talk about things that a lot of times people just don't want to talk about. So there are a lot of changes, and I want you to talk about some of the stuff that's proposed and going through Congress that could really affect what we can keep and what we're not going to be able to keep. So our first topic is called a SLAT, S-L-A-T, Spousal Lifetime Access Trust.
Welcome to the Jennifer J. Hammond Podcast. Jennifer is a licensed realtor, educator, speaker, and best-selling author. Jennifer's goal is to help you find your yay in every day.
Hello. This is Jennifer J. Hammond, and I'm so excited. As you know, I love when we can bring you great information, and there are some tax changes that could really affect you and building wealth, passing the wealth on. So it's really important. We have a special guest who's here with us today. He's an attorney who specializes in not wills, but estate planning. But his name is Will Andersen. Welcome back to the show.
Thanks, Jennifer. Good morning.
Good morning. I'm so excited because, we talk about things that a lot of times people just don't want to talk about. So there are a lot of changes, and I want you to talk about some of the stuff that's proposed and going through Congress that could really affect what we can keep and what we're not going to be able to keep. So our first topic is called a SLAT, S-L-A-T, Spousal Lifetime Access Trust. So tell us about a SLAT.
Sure. And if you don't mind, I'm gonna start by giving people a little bit of the history of what we're dealing with here, just to kind of make it so that we can understand the situation. There are some potential big estate tax changes that are coming. I always say to people, look, estate planning is about way more than estate taxes. But hey, today it is about estate taxes. And historically, when you hear people talk about death taxes and things of that nature, we're talking about taxes that the ultra high net worth clients are going to be facing. It affects 1% of the population or less. But at the end of the day, there are some changes that are probably going to expand that number a little bit. And so, historically, it wasn't that long ago that the estate tax exemption, meaning how much you can pass during life or at death, was around $675,000. It was very low. But it gradually rose a little bit by little. And at a certain point, it got up to $5.5 million per person. Now, George Steinbrenner, the owner of the Yankees, he's the one guy who beat the estate tax. He was the luckiest man in the world. He died in the year that there was no estate tax. And fun fact, that's why his family was able to keep the Yankees. They would have had to sell the team in order to pay the estate tax. But he did it. He did it in the right time. But for the rest of us, finally got up to $5.5 million per person. Republicans were happy. Democrats were happy. Nobody was really looking at it. But then you may remember that we had the Tax Cuts and Jobs Act passed by the previous administration back in 2017. And one of the things that it did was it doubled those amounts for everyone. Now, this is, of course, a great thing for a lot of clients that said, oh, well, this is wonderful. Now, we have more options. I have more wealth that I can pass without being assessed a tax on it. And by the way, I just realized I didn't tell you what the tax is. Right now, everyone can pass 11.7 million per person. And anything over that, you're going to be taxed at a rate of 40%.
Woo!
Yeah, so 40 cents of every dollar. So I always say we can give it to the family or we can give it to the government. It's up to you.
Wow.
But the biggest problem that I found with that is it gave people a false sense of security. They think that because, well, I don't have $11.7 million, or because between me and my spouse, well, heck, we don't have enough for this to be a concern for us. We have $15 million, so we don't have a problem. Well, what they're not telling you is that law, as written, if we don't have any tax changes, sunsets in 2025. It's going to go back to those original numbers.
Oh.
That part didn't get advertised. And so I tell people, look, unless you plan on dying between now and 2025, it's not going to do a whole heck of a lot for you. But right now, we are in a place where there is legislation. I think it's called the 99.5% Act, which would reduce those numbers down to $3.5 million per person. And we're not looking at 2025. We're looking at, it could be any week. We don't know when it's going to happen. Whenever Congress gets it in gear, and I know that's a high bar, but whenever they do decide to do that, that's when it's going to happen. So I'm telling people, look, we got to do the planning now. And I'll tell you, I've got so many clients right now who are scheduling meetings and saying, don't start this off with an "I told you so." But anyway.
Well, nobody likes to hear "I told you so." And
that's
then again,
right.
like I started this today, nobody likes to talk about death. And so talking about, well, nobody really likes to talk about death or taxes, but we try to make it interesting and make it fun. And we try to make it so that you realize, wow, if you think about 40% of your money going away, then maybe it's worth taking the time to understand, the laws and how they're going to affect you, your family, but specifically for somebody, for each spouse, shall we say, for spouses, plural.
Right. No, you're exactly right. And it is so much not a fun thing to think about that it can have really drastic consequences. And I'll tell you another little anecdote here. Philip Seymour Hoffman, he was in Capote. I know that he was in Hunger Games. Really famous actor, did very well for himself. Well, he was a guy who did an estate plan. He drafted a will, which is better than nothing, back when he was 20 or so, and he was dating his longtime significant other. And so at that point, he, of course, left everything to her. Well, in the meantime, his career took off. And all of a sudden, he has a massive estate. I want to say it was $30 million by the end of his life. And at the end of the day, he never updated his documents. And he also never married his girlfriend. Now, a lot of people don't realize there are big consequences if you don't get married. I've had people propose in the middle of meetings when we talk about this. But at the end of the day, the way that this works for him is that when he died, normally, if he had gotten married, then there would have been no estate tax due until the second death, until his wife passed away. Yes, we may assess what tax he may owe at that time, but we don't have to pay it until she passes. And in their case, he was very young. They would have had another 30, 40 years before that would have come due. Well, instead, what happened was he passed. They owed an estate tax, had payable within 9 months before it goes to his spouse. Now, here's the kicker, the real big one. Now, so we've had the estate tax assessed once on this money. Now, what happens when she passes and it goes to their kid? It's happening again. The money's going to get hit with another estate tax. So, guys, if you're thinking about, I have no reason to get married, this works just fine, then why should we do this? Well, there's a big one. I've got 7 figures worth of reasons for you to go ahead and pull the trigger. And for my same-sex couples out there, Obergefell passed, guys. You don't have an excuse anymore. Go get married. So at the end of the day, that's just one of the big consequences that can take place. Now, to get back to what we're really trying to talk about today, spousal lifetime access trusts, these are a way that you can pass the wealth using today's numbers. We can get the wealth out of your estate today using that $11.7 million number, while still making sure that you retain control over the assets. But even better, the fact of the matter is that you are anything that takes place in the future, you can buy and sell property, you can operate businesses, you can do whatever the heck you want, but any future growth is going to take place outside of the estate. So I don't care if your estate grows to $100 million, you're never going to be assessed an estate tax. So here's the way that this works. If we have a married couple, then we have a husband set up a spousal lifetime access trust, or a SLAT, for their wife. And then wife will be the trustee and the beneficiary of that trust, meaning she's everything. She's the trustee. So she's the decider. She's the one who controls the purse strings. She's Congress in this equation. But she's also the beneficiary, meaning she's the one that gets to benefit from the money. And I'll stop my, that's also a Congress joke, but at the end of the day, she's the people as well. So she gets to do whatever she wants with it. She gets to make all the decisions, and she gets to use the money, and vice versa. So we both create these slats for each other. Now, I mentioned at the top that we have that estate tax exemption. It says this is what you can give during life or at death. And yes, it is a simplification, but the fact of the matter is that today, if you can leave $11.7 million when you pass, well, Uncle Sam wants to make sure that you can't circumvent him and get around giving him his money. So by just saying, well, fine, I got an idea, I'm going to give it away today. Well, no, he says that you can also give $11.7 million. But if you give more than that, then all of a sudden you owe a 40% tax on everything that you give. So
wow.
These numbers are tied together. So this is the one way that we can use these numbers today to help us tomorrow. So we essentially split the estate in half, and each spouse is going to give half of the estate to each other's trusts. And now we file a gift tax return. We make sure that we have claimed essentially everything in the estate, so that now, let's say that for really easy numbers for me, let's say that it's a $20 million estate. Well, then great. We're going to cut it in half. We're going to each gift $10 million of assets to each other's slats. And at this point, it's out of the estate. You no longer have to be concerned about to what's going to happen tomorrow with the estate tax. They can drop it to $1 million for all I care. But now when that number drops down, then that's fine. You're grandfathered in. Yeah. And so you still have complete control.
Good.
Now, the one drawback, and this has never been enough to make a client say no, the one drawback to this is that when the first spouse passes, it does not go back to the other spouse. It just doesn't work like that. You can't have it come back to you at the end of the day and still avoid the estate tax. So that just means that your half of the estate is going to drop down to the kids, on the first death. Now, look, for people that we're doing the strategy for, that's not going to change the brand of wine you're drinking at the end of the night. But it's something to be conscious of. Now, one really good way to somewhat help that situation is for the use of a limited liability company. Mm-hmm. We can use a holding company for really any business purpose asset that you own, whether it's rental real estate, whether investment properties, whether it's an investment account. I mean, what's a business purpose? To make more money. That's why you have your money at UBS, Morgan Stanley, Merrill Lynch, whoever's holding on to your accounts. Well, that's why you have them. So great. Let's put all of that into an investment company. And now you've got to remember, we have the separation between the owners of a business and the managers of a business. So if husband and wife are the co-owners of this business, 50-50 ownership, and they're both 50-50 managers, well, that works perfectly while you're alive. You do whatever you want within the company. When the first of you goes and that ownership drops down to the kids, well, the managers, That didn't drop down to the kids. Now the remaining spouse, they're the sole manager of that company. And yes, the kids would have a right to a distribution. So, if mom wants to go play slots in Vegas for a little bit and wants to take a few $1,000s out to go do that, well, that's fine. She's going to have to give the kids a little bit of a share in theirs as well. But she's the one that's still controlling the investment. She's doing what she wants to do. And so by doing this, it's a very simple way to fix a potential estate tax issue. Now, let me be quiet for a second, Jennifer. I know that's not my strong suit. Let me ask if you have any questions.
Well, I think that's the big thing is if there is a chance to save on estate taxes, to save on what you're going to give to the government, I think we all want to know that. So number one, just kind of to summarize, we're looking at a SLAT, which is the spousal, say it again.
Lifetime Access Trust.
Okay, good. So I think it's really important. And then did the charitable remainder, what about that?
So that's a really good point. Now, for a lot of people that are listening to this, they're saying, Will, this doesn't apply to me. I'm single and ready to mingle, whatever the case may be. I don't have a spouse that I can do this with. So what is it? What options do I have? And of course, there are other options out there that we can talk about. There's no such thing as cookie cutter estate planning. If somebody's offering cookie cutter estate planning, run. But proper estate planning, every client is a puzzle. And so, the charitable remainder trust is something that I'm using for a lot of clients right now in order to fix a potential estate tax issue. I'm also using it as a bit of a hedge, meaning if we use a strategy where it's going to take a lot of time to fix that issue, then we can use the charitable remainder trust so that if you pass before the final implementation of your plan, that your kids are going to be using the money. They're going to get use of that money. So I like to say, when you write out when they assess what your estate tax issue is and you write the numbers into the check, the question becomes, whose name are we putting on the check? And right now, if we use a charitable remainder trust, we put the charitable remainder trust's name on there instead of the IRS. So I'll go through this with you on how this works. And so a charitable remainder trust, don't let the charitable part fool you. Yes, the charity is going to receive something from this, but this is something where even if charity has nothing to do with what you're trying to do with your estate plan, you have no philanthropic goals, that's okay. This is still a strategy I'd recommend. But I'm going to use an example of a person that has, let's call it an $8 million estate. And they're concerned about when the estate tax finally drops, back to 5.5 if we make it to 25, which I don't think we will, or if the current legislation passes, then it drops down to 3.5. Well, now they've got an estate tax issue. They don't have a spouse whose exemption they get to use. There's no gifting between spouses that they can do. How do they fix it? And especially the biggest one, I don't want to give it to my kids today. That's my money. So what we can do is essentially create an empty shell of a trust. And this trust, you list some charities that you like as the final beneficiary on it. But we are going to list your kids as the lifetime beneficiary. Now, with this trust, it's going to be an empty shell until you pass. You can flip your last nickel into the air as you take your last breath. That's fine. And then it's nothing but an empty shell. We didn't even apply for a tax ID number for it generally. I mean, it's got nothing in it. There's no reason. But when that client passes, well, let's say that they do have an estate tax. Let's say that day it's assessed that you owe Uncle Sam $2 million. Well, instead of giving it to Uncle Sam, we need to have a provision in your revocable living trust that says, and that's just your foundational estate plan. But it says, if I owe an estate tax, instead of giving it to the government, I want you to give to my charitable remainder trust what would zero out my estate tax. And right now, that's a dollar for dollar deduction. You are able, so instead of writing IRS on that $2 million check, your trustee writes the charitable remainder trust. And so now the kids are going to receive a certain percentage of that account value every year. Now, for my more technical people, this is a charitable remainder unit trust. So people are saying, which one? Is it a CRAD or a CRUT? Okay, it's a CRUT. But the reason for that is because it's not, the kids receive X amount of money every year. The kids receive X percentage of the account per year. So, Jennifer, if you're my financial advisor, then I'm going to call you on January 1st and say, hey, Jennifer, what's the account value? And you're going to say, Will, it's New Year's. Why the heck are you calling me? I'm going to call you back tomorrow. I'm going to say, okay, what's the value on the account today? And you're going to say, all right, it's $2 million. All right. So then we're going to, what's 8% of that, Jennifer? You're going to give me the number. And then we're going to distribute that out to the kids. And then we're going to do it again next year and the next year and the next year. And hopefully that account is going to be making money at the same time. Now, you, client, have control over how much the kids are going to receive. You have control over that percentage. The only requirement here to keep us on the right side of the IRS is that it has to be likely that the charity at the end of the day is going to receive 10% of what the initial value is. So using my example where we had a $2 million estate tax payable, then it has to be likely that the charity would receive $200,000.
Got it.
I like to keep that percentage number under 10%. Some people say, 10%. When I first started working here on the design, there were big red letters. It said, do not go over 10%. and so, I know that some people do 10% per year, and that's probably fine. I'm a gambler, but not with my clients. And so I don't want to gamble with you. I'll do that on my own time. But at the end of the day, I generally like doing something between 7 and 9%, and that by actuarial tables works. So this is a way that the kids get to use the money. Now, what are the downsides? The downside is what you kind of left on the table in terms of the kids' control over the money. Now, it beats the heck out of them not having it. Don't get me wrong. But for
something is better, a percentage of something is better than a percentage of zero, right?
That's exactly right. Now, so for the rest of the estate, if we have proper estate planning done, then everything, and this is for estate tax or not, everything should drop down to the kids completely asset protected so that no creditor, predator, divorcing spouse, lawsuit in the future can ever come and take it. Any of those bad actors, I want to make sure that your kids are going to receive the money, and no matter what happens in their life in the future, we know that what mom and dad left is going to be there.
Yeah.
But the great part of doing some other strategies is the kids can have as much control as you want. They're the trustee, they're the beneficiary, they get to keep all the great asset protection benefits, but they are at the same time going to have total control and access to the funds. That's not the case with the charitable remainder trust. They get a cold, hard percentage on an annual basis. And so, of course, yes, I'd rather them be able to use that money than not get to use it at all. But in Will's perfect world, if we get proper estate planning done, then that doesn't necessarily have to happen.
Right.
But at the same time, we don't want to let the tax tail wag the life dog. And some strategies they do put a squeeze on what you can do with your money. They get complex, and this is also a great strategy for my client that says, "Look, I'm going to be dead. What do I care? Or you're going to uproot my life right now. It doesn't. It's not a big deal. That's fine. Using this strategy, it is a hedge. If you're like George Steinbrenner and you die in the year that there is no estate tax, fantastic. It's nothing but ink on paper. We throw it in the trash. We never apply for a tax ID, and everybody rides off into the sunset, a happy camper. But
Right.
if there is one, we've taken the steps necessary to make sure that at least the kids are going to get to use it.
Yeah. Yeah. And I think the thing that's really important, Will, is that you have a plan in place and that you've actually talked to an advisor. I think it's the thing that scares me so much is when people don't have any plan and they're, like I said, they don't want to talk about it. You're talking about two really tough subjects, taxes and death. And those are two subjects that a lot of times people shy away from. And so I just encourage you to call a professional. And so now, will you share your information about how they can get a hold of you? Because again, I want to make sure people know that you can help in many states, right?
All 50
All
and international. We have clients in all 50. Now I've got an argument that we don't have a South Dakota client yet. I haven't poured through the books, but I believe we do. I think they're wrong. I'm here to talk to anybody who wants to have a conversation. You can give us a call at 866-230-2206. You can go onto our website and you can book an appointment right there on the website at www.theandersenfirm.com. Or finally, feel free to email us, and you can do that. You can email Mel, MEL, at TAF, Tango Alpha Foxtrot, .LAW, Lima Alpha Whiskey. So Mel at TAF.law for the Andersen Firm. So no .com. But Mel is the person who runs the scheduling for the whole firm, and she'll be happy to get you an appointment.
Perfect. Well, and as you know, I'm always looking.